Senator Schumer said earlier today that the eyes of the founders are on these proceedings. Indeed, that's true. But it is the heart of the Constitution that governs these proceedings. And what we just heard from Manager Schiff, courts have no role, privileges don't apply. What happened in the past, we should just ignore. In fact, Manager Schiff just said, try to summarize my colleague's defense of the president. He said it not in those words, of course, which is not the first time Mr. Schiff has put words into transcripts that did not exist. Mr. Schiff also talked about a trifecta. I'll give you a trifecta. During the proceedings that took place before the Judiciary Committee, the president was denied the right to cross-examine witnesses. The president was denied the right to access evidence. And the president was denied the right to have counsel present at hearings. That's a trifecta. A trifecta that violates the Constitution of the United States.
ACLJ Chief Counsel Jay Sekulow, acting in his private capacity as counsel to the president, making very forceful arguments on the floor of the United States Senate in day one of the impeachment trial. Folks, it's hard to imagine that we are here, but here we are. One day of the impeachment trial in the books, day two just minutes ahead.
We had a very strong start yesterday, and here's why. With all the arguments that were made, and remember, most of this was procedural, but they were having to put their whole case out through those motions. Not one of them passed. The Republicans held, and I can tell you that as they closed at night, and that was before, a lot of people, unless you're on the West Coast, didn't see what Manager Nadler did. But by calling the Senate treacherous if they do not do what he wants, and by again attacking them, he said they were on trial. So now he said that 4 times, twice on the House floor, now on the Senate floor, and in a press conference. And then called it treacherous if you don't vote their way on amendments. That is not how you talk to the U.S. Senate. It's not how you talk to any jurors in any case. We appreciate your prayers. We appreciate your thoughts. And we're about 25 minutes live, about 25 minutes from going out. So we appreciate it, and we'll be talking to you soon.
The Senate was in session from about 1 p.m. until about 2 a.m., so about a 13-hour marathon session ended just before 2 a.m., I think about 1:50 a.m., and most of the day was filled with debate on amendments to the rules. Now, as expected, the organizing resolution that was put forward by Leader McConnell, it prevailed in the end. It tracks closely with the 1999 rules that governed the Clinton proceedings. The Democrats offered 11 amendments to those rules, various amendments to offer subpoenas and other things. All 11 of them failed. The only real modification was that Leader McConnell agreed to let both sides have 3 days instead of 2 to present their case to the United States Senate.
While Democrats fervently argue in favor of fairness, they ignore their own participation in hearings without due process, without elementary fairness, without respect for Article 2 of the United States Constitution, without respect for the fact that the United States Senate has the sole power to try an impeachment case. And so I think the Democrats have to confront a conundrum of their own making. They decided on an unfair process. They decided to rely largely on hearsay witnesses. They decided to bring a truly unconvincing case to the American people and to the United States Senate, and now they seek to enlist the United States Senate in basically rescuing their botched and shoddy investigation.